the challenge here, madam? What is the allegation? This is a case of misappropriation. Misappropriation. Why is the petitioner not representing any idea of this? Hmm? So there is some person who is going to appear in person. How is the petitioner a workman? You were an assistant teacher.
Assistant teacher.
Then how is she a workman,
She's
or
not
how
a
did the
workman.
labor code take into anything?
He's not an actual workman, but Lordship, after they
Now, if he is not a workman, then does it arise anywhere that this person concerned can be brought within the ambit of the labor code? A reference can be made.
the reference has been made to that effect. We appeared.
Understood, but is it possible?
Lordship, I do not have the authority to question. Yeah, it's not possible. But the management does not have the authority to question the reference, order of reference. Supreme Court has said time and again from the elements, but authority case. So we appeared, we participated. I She does not actually fall within the purview of workmen. It's only the salary and that the fact that she does not take any super managerial decisions. On that count, they want to say that she's a work.
There's a legal aid counsel, her name has been shown. Is B. Chaudhary.
Her name has been shown? I think so. She's not
Yeah,
an
yeah.
issue, that's amicus.
But
You
the
can- you can
problem
refer-
arises
you can-
how is being a teacher. Let's see the charge sheet. Teacher under suspension. Teacher.
Yes.
How can a teacher be a workman?
The fact that she's the employee of the tea
Hmm?
garden, that's the reason.
No, being an employee would not.
Don't make her.
It is something a teacher has a managerial status.
Teacher does not have a managerial status. Not per se, not a
No, it
decision.
cannot come within the ambit of the workman. Hey, industrial dispute settlement. So against the termination, the reference was bad, but the challenge could have been only in the civil court.
Yes. But she also had, was in charge of the midday meal. She was performing
Hmm?
dual duties she had lot.
Workmen's means any person, including an apprentice, employed in any industry to do manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purpose of any proceedings under the Act in relation to an industrial dispute, includes any person who has been dismissed, discharged, and so and so. Who is employed mainly in managerial or administrative capacity.
Her lordship, her limited role, but she was dispersing the in charge of the midday meal.
So that means it is some, this has the status of a managerial for looking after that, or in an administrative capacity.
May I please, Nasib? On behalf of legal aid counsel, Ms. B. Chaudhary, time may be granted to her in this case.
Then we have another legal aid counsel. If the legal aid counsel is not in a position to help this court, and help it. It's a matter of 2017. Doesn't look nice. And the petitioner wants to appear in person. Okay, we do one thing, madam, we fix it on another date. We just look into this. So the award may not be proper, but the question of termination cannot be touched. Taking into account that because if she doesn't come within the ambit of a workman, and because her
Then this
duty
will
was what? She was a teacher. Secondly, she was in the administrative capacity of looking after the day-to-day
midday
meals.
meal scheme.
Tomorrow
But she
yes, you are there. Yes. Tell me.
It is correct. I was watching your lordship recording. She was discharging her responsibility as an assistant teacher in a school.
Now the charge sheet says teacher under suspension, meaning she's a teacher.
Teacher.
One, a teacher cannot be relegated to the post of a workman. One. Secondly, what was she doing was in more of a administrative work, considering the fact that she was in charge of looking after the day-to-day midday meals. And there's some misappropriation made. This is an allegation. That allegation has been proved in a disciplinary proceedings. Now, whatever the termination has happened, the question of making a reference would be very difficult. That if she is not a workman, where is the question of an industrial dispute? An industrial dispute may come within the ambit of a civil court.
that even the writ goes.
Hmm?
In that even the writ goes, lordship.
Hmm. But the reference which is being made, any order passed in the reference proceedings would be a nullity if the reference is wrong. So the only thing is that to give the liberty to challenge in the civil court, and that will be only not a question of reinstatement. It will be a case of the what do you call damages.
Absolutely.
The question of
Yes, after this-
reinstatement cannot arise. It
Only
will be a wrongful termination.
If it's proved to be wrong.
Huh?
if it's proved to be wrong.
Obviously. No, it would be a case of wrongful termination, nothing more than that. Anyways, you have a look at it, if I'm not wrong.
Not sure if it's a date.
Madam, you just look into this.
Yes, Lord,
In my opinion, it cannot be a reference.
yes, Lordship, because she was not a workman.
Well, she
doesn't
couldn't have
come
been a
into that.
workman. If she is not a workman, the question does not arise. So then the reference has to be held to be a nullity. And then giving her, and the question of reinstatement does not arise. It will be a case of filing a civil suit for wrongful termination. Have a look at it. We finish it on next Tuesday
Next Tuesday.
or next Thursday. Item
Whatever.
one. Item one, next Thursday.
24.
Matter, this court heard Ms. B. Chaudhary, the legal aid counsel, as well as Mrs. M. Hazarika, the learned senior counsel, assisted by so and so. Upon hearing the learned counsel and taking into account that the petitioner herein was a teacher in the establishment of the respondent company, Tea Garden,
Udalguri
and
Garden
the
Primary School.
petitioner was discharging her duty discharging her duties, and the allegations made against her pertains to discharging administrative duties. A question arises as to whether the reference proceedings at all was maintainable, taking into account that the petitioner prima facie do not appear to come within the ambit of the definition 2S workmen, within the ambit of the definition workmen as defined in section 2S of the Industrial Disputes Act 1947. Considering the same, if that be so, it is also the prima facie opinion of this court that the entire reference proceedings would be a nullity. And at best, the case of the petitioner would be against wrongful termination. This court would hear that the learned counsel is appearing on behalf of the parties on further on 31st of July 2025 to list the present proceedings again at 10:30 a.m. at the top of the list. Yes, Mr. Roy.
Well, the very fact of the case is this, Lordship, that the petitioner is running an industry for manufacturing the TMT at Guwahati, Borangang. And he has the connection of the high tension line. Lordship. And the engineer of the APDCL, Lordship, visited the factory premises, Lordship, and prepared an inspection report. And thereafter, Lordship served the assessment bill. That assessment bill ultimately, Lordship, the petitioner preferred an writ petition, and the Honorable Court directed to deposit 50% of the provisional assessment bill. Accordingly, the petitioner deposited the 50% of the provisional assessment bill. Then, Lordship, the matter ultimately the appeal was filed by the petitioner lordship before the appellate authority as provided under section 126,
127.
127. And the appeal was allowed in favor of the present petitioner lordship, and the APDCL was directed to calculate the actual provisional will again. Accordingly, the it was APDCL reconsidered it and reduced the amount lordship than the earlier amount. Thereafter, lordship, that amount was paid lordship by the petitioner. Thereafter, lordship, again the respondent lordship served the notice.
In
for
respect to
paying,
the same period.
lordship,
In respect to the same period.
same period. And demand is almost rupees 1,22 lakhs from the petitioner law, which was again appeal was filed. And that appeal was also allowed and directed the APDCL authority lordship to reconsider the bill. Thereafter, the bill was reduced to 21 lakhs lots, which was also paid by the petitioner. Then, my lordship, after almost 2 years, again a reassessment bill was served on the alleging that there was a audit report, and the audit report there is a objection. As such, again a revised bill was come, which is now challenged by the state petition law. Because when the appellate lordship may please come to the appellate authority finding, page 113.
Yes, Mr. Sharma, what is it?
My lord, may I just read the facts of the case? My lord, what happened? The first petitioner hearing was provided with a provision assessment bill. He appeared for appeal under section 127. While he applied for section 127, my lord, he also gave a miscase there that the pre-deposit clause should be stayed. Then he referred the matter to the High Court. The High Court said that no, you have to deposit 20 lakhs, and accordingly the appeal has to be heard. The appeal was heard. After hearing the appeal, the amount of reduction as per section 126 should be 12 months. So that was reduced to 84 days. And that is not under challenge, my lord. When that bill was produced there was a calculation error that was found by the audit, where as per if there is no tempering of the meter, then 4.2.2 comes into application. But the moment there is a tempering of the meter, the calculation should be as per
5.5.4.
Yeah, 5.5.4. And thereafter, we on the 84 days only, because he has not challenged the AERC order or the order of the appellate authority, we revised the bill and we submitted to him. His writ petition is, my lord, that we are not allowed to do so. But we are contending that it's a bona fide error on our part.
Let's see the initial, the order passed by the, yeah,
my lord.
your first assessment. Where is the provisional assessment?
Provisional assessment lordship.
Page 31.
Yes. Page
32.
32, it starts.
Page 32, my lord.
Page 30.
So it was 1 crore 59 lakhs.
Yes, my
Yeah.
lord.
Then he filed an appeal.
Yes, my lord.
This was done for the whole year, isn't it?
My lord, it was done for
Provisional assessment was done for what is the
It
period?
was done for 16 months.
16 months,
16.
my lord.
As per law lordship, it should be only
12.
12 months.
12 months.
So it was done for 16 months. Anyway, then against that he has filed an appeal.
Yes, my lord.
Then,
Then, my lord, at annexure 11, page 51.
wait, annexure 11, then he was asked to final, then there is a final assessment. So the
Yes.
provisional assessment was made final.
Yes, my lord.
Okay, then the appeal comes against the final assessment order.
My lord.
Then disconnection notice given, then he
Yes.
files writ petition.
Writ petition. Writ
Writ
petition is
petition
disposed of.
order is at annexure 13, page 63. Directions so passed here.
Then the order, my lord, the order, the direction is that,
Having held so, this court, the following order is passed in terms with the agreement between the parties. So it is a consent order,
Yes.
yes, ma'am.
page 67. The petitioner shall deposit 20 lakhs by way of a bank draft within a period of 3 days from today, and such deposit electric connection shall be restored. He is given time for a period of 6 months from today to pay either the lump sum or in installment as may be convenient to the petitioner 50% of the assessment bill. And on such deposit, the appellate authority will take the appeal on record, entertain the same. So on installment basis, he was directed to pay 50% of 1 crore 59.
Yes, ma'am. The pre-deposit.
Okay.
Who has
Then-
deposited that?
So the petitioner deposited that
Ah,
1
yes,
crore.
madam. And then the order of the appellate is at page 69.
After hearing both the parties and taking into account the documents and photographs submitted here, found that the malpractice was committed by the appellant, but the amount of penalty bill is not correct at all. There is no malpractice till Iman is directed to correct the bill in the following manner. The assessed period should be from 10/4/2000 Iman to 4/7, only 84 days. And the average per day consumption should be calculated from 1/7/2014 to so and so. As per so and so, and using the formula 2 average consumption per day prevailing rate during the assessed period. If the new penalty amount is less than the already amount, it should be adjusted against future bill.
Madam.
So this is the direction to do it in terms taking it as a malpractice
Malpractice.
for 84 days.
84 days. My lord, it should be 86. There is a calculation error because my lord, 10/4 to 4/7, if you calculate, my lord, it's 86 days actually. There is a typographical error.
But you have not sought for correction of that.
No, my lord, we the period of bill that we have calculated.
Have you sought for rectification of this sort?
No, we have not.
So it is, we'll take it as 84
My
days.
lord,
Then final assessment amount, statement enclosed 21 lakhs. Already pays so and so, amount to be adjusted in subsequent year is 58 lakhs.
my lord.
So this is being done pursuant to that order.
Yes, ma'am.
Then revised bill for so and so. This was done when? In 16, 21/3/2016. Then you issue a notice on 25/7/2017 after 1 year
My lord.
because of the
Objection,
audit.
audit objection, ma'am.
And as per you,
The period is similar, my lord. As per the appeal order, the same similar period, my lord.
but you have taken 86 days.
My lord, if my lord, in an arithmetical calculation, it will come 86 only. 10 to 21
So the appellate authority took it
did not
by
calculated the 10,
the,
4 and
no, did not calculate the first state and the last state.
state.
So it comes to 1 crore 44 lakhs.
Yes, ma'am.
Then
Then the revised assessment bill was issued.
already paid. So 21 lakhs having been paid. So now it comes to 122.
122 crore. Then he submitted an application against it.
Right? So now we are concerned with this 122.
Yes, my lord. And my lord, thereafter, another writ petition was filed by him.
Ah.
There was another writ petition that was filed by him. That is at page 80, annexure 21.
Challenging this.
Yes, challenging this.
Then what happened? What is the
The
order?
order is at, my lord, page 96, annexure 22. And the effective part,
In view of this discourse stands disposed of, directing the petitioner to file a fresh representation before the respondent number 5
within a
within
period
a
of 3
period of agitating the issue raised in the writ petition. If such a representation is filed within a period of a year, the same would be disposed of after giving proper. The respondent number 5 would also be at liberty to consider as to what interim protection can be granted to the petitioner in the facts and subject, taking into account the fact that a heavy amount has been slapped on the petitioner after a lapse of nearly 2 years, if such relief is sought by the petitioner. Until such time the exercise so directed is permitted, this connection shall not be affected. Then,
he submitted his representation.
and where is your order?
The order is at 113, annexure 25.
Method adopted by the court for calculating the assessment bills were irregular. May be stated that while making assessment, the basis of average consumption was applicable in case of incorrect or stop meter, where there is no mala fide intent of the, in the inherent case. The tempering of meters which tantamount to theft were willful acts on the part of the consumer. Hence, the provision of 5A of the year which provide for assessment of consumption in case of theft of electricity were applicable in these cases. The observation of the accounting found to be correct and accordingly as per the directive the bill be applied. So 4.2.2.4 is in respect to what?
Normal bills. Will become the normal bill.
And procedure for assessment of consumption in case of incorrect or stop meter.
Yes, ma'am.
Incorrect. And what is malpractice?
My lord.
Because here the appellate authority held that there was a malpractice for
Malpractice.
84 days.
Yes, for the malpractice, it is 5.8, 4.4. My lord, I have given, it's a huge tool. My lord, if my lords allow, may I just take a printout of from it there? I've already given it in the software. Yes.
Where is 5.8? You have it? Five-
Yes,
Now, do you have a power of revision?
my lord, we do not have the power of, it's not a power of revision that would like, if there's a bona fide error on our part, under section 56(2), we have the right to correct the bill. And that's the same has been held by the Apex Court. When the 56(2), when we regard provision 56(2).
Electricity Act.
Yes,
Now, this is for theft. Theft and malpractice is not the same.
not the same. But
Then-
my lord, when there is a bona fide error on the bill, because he has.
No, I'm saying, can you say a theft and a malpractice to be one and the same?
My lord, it is
When
not.
there is no allegation of theft, there is no allegation of theft being proved.
Lordship, actual fact is this.
2013.
Actual fact is
Mal-
there was no malpractice, Lordship. The meter was burned.
No.
You
You
took-
see, that order has attained finality. That there is a malpractice. But whether malpractice and theft would be one and the same, I'm asking.
Entirely different, two different.
Has the malpractice been defined somewhere?
Yes, my lord, at 5.8, 3.1, my lord,
5.8,
3.1.
malpractice, contravention of the provisions of Iman electricity or any other law governing the
the-
supply of energy regulating shall be treated as malpractice, and the consumer indulging there shall be liable under law, rule and order.
Then, my lord, the provision that comes.
Exceeding unauthorized
Use of
supply of electricity to any service which is disconnected, exceeding load. Theft of electricity as detailed under 135 will come within the ambit of malpractice.
Yes. My lord, and in fact, 5.A, 4.4, my lord, it's been.
Huh?
5.A, 4.4, when a consumer indulges in the theft of electricity, the authorized in behalf of the government without prejudice to its other rights will assess the quantum loss on the basis of.
But wait, no, understood.
Yes,
You
ma'am.
see, there are various parameters for malpractice.
Yes, ma'am.
It may use unauthorized supply of electricity.
Yes, my lord.
It may also be theft.
Yes, ma'am.
But where is the finding of the appellate authority? It may be a malpractice that it is theft, but for theft and unauthorized supply, is it under the same purview that you can very well carry out this thing same?
My lord, if.
You see, just for example, 5.A.4.1, use of unauthorized electricity load exceeding authorized collected so and so. For such nature of negligence, assessment bill will be made for the category specified below as per the formula stated below for a period of maximum 6 months.
My lord,
Domestic agriculture, so and so, Iman, so and so. So this is a formula. Then resale of electricity is different. Then why have you put him under the purview of theft? My question is that.
yes, my lord, may I read, may I put it here, my lord, this?
Huh?
My lord, may I just put it, my lord,
Please put.
my lord, 5.A.3, my lord,
Uh,
malpractice, contravention of any provision, electricity 2003, the Indian electricity rules or any other law governing the supply regulating order shall be treated as malpractice.
Understood. No,
Yes.
there is no quarrel. The various instances of malpractice is given at 5.8.3.2.
Yes, my lord.
So, but in this very code itself, it says that in respect of some, that a various forms of malpractice will be computed in a different manner. Just for example, the theft will be done as per 5.8.4.4.
Yes, my lord.
Okay, what does it say? When a consumer indulges in theft, the officer authorized in that regard may, without prejudice to its other rights, will assess the quantum of real loss on the basis of the assessed consumption of the detected category as per table 6.2.1 and the connected load for a period of 6 months prior to the date of detection and will be billed at the rate of 1.5 times. But this is not there in respect of others. Finally, see, resale,
My lord, subject to the 5.A.3.2,
Hmm.
subject to the generality of above cases mentioned here, shall be generally treated as malpractice. Generally be treated as malpractice.
understood. So
Yes.
malpractice
So
can
the
be
mal-
on various accounts.
Yes. It
So
can be
it may
theft
be
of-
exceeding connected load,
Yes,
would also be a malpractice.
yes, my lord. Unauthorized supply.
Similarly, theft will also come.
Yes, my
But
lord.
where is the finding that there is a theft to come within the ambit of 5.8.4.4 and not 5.8.4.1?
My lord, the tempering was there, but the theft.
Tempering is different.
Yes, my lord. There's observation of theft is not there, my lord.
Then why you are doing it as per theft? What is that is why we have to now read what is actually observed by the appellate authority. Let's read page 69.
The appeal was heard on 22/12/2015. All the parties were present. Explain the case in brief is that meter number so and so was burned suddenly. In the last part of inspected site and after physics, it was suspected that tempering was done. The meter was seized and dismantled before the representative of the company. AGM also found that paper seal the meter cover was in broken condition. There was a crack in the meter cover and also suspecting opening of the meter cover. So the meter was taken for further testing. The meter was tested in presence of representative of appellant and also expert of secure meter, who is a manufacturer meter, was also present. During the testing, it was found that data can be partially downloaded and there was no display. When connected to secure test branch, polycarbonate seal was found partially broken. The meter was handed over to secure meter for further testing in the laboratory. Secure meter confirmed that the meter was tampered and has been modified to alter the accuracy of the meter. Finding this anomaly, ICR served a final penalty of so much, agree whether the party has paid 50% and appeal. After hearing that all the malpractice was committed by the appellant, but the amount of penalty is not correct, so and so, the assessment period is so and the average day 84 days prevailing rate during the assessed period. If the new penalty is less than already paid amount, it should be adjusted in future.
And the assess period should be from so and so, and the average per day consumption should be from so and so to so and so only. And the average per day consumption should be calculated from so and so as submitted by so and using the formula 2. What is this? 2 star
2 into average compression.
2 into average
compression per day into 84.
prevailing rate during the assess period.
Yes.
So this is the formula given.
Yes, man.
Then if you have not challenged this appellate order, so can you get anything else?
No, my lord, and the average per day consumption should be calculated from so and so using the formula 2 so and so. So now, my lord, when there is it is nowhere disputed that there was a.
No. What is this? And the average per day consumption should be calculated as so and so.
Yes,
And using the formula
yes, my lord.
2 into average consumption per day
Per day. That is not. That is
into
not.
84 days.
Yes, my lord. That is not.
Prevailing rate during the assess period. If the new penalty amount is less than the already paid amount, it should be adjusted against full bill of the party. Now, how did you for 16 months? What was the rate? This must have been done. Now you have come up with a different case. You have wrongly done it. Without seeking this rectification, how can you do that? Your calculation bill is this. Kindly see this. Kindly come to page 33. One crore 50 lakhs 26,454 minus 70. 70 is the amount unit change. Unit charge. So this must have been the amount into 2 is equals to this much.
Yes, my lord.
So this appears to be therefore the same
Yes.
formula being used.
Yes.
So you have done there. So without a correction being made to this appellate order, how can you change anything else?
May I just come in here?
Isn't that your case?
Yes, Lord. May I just come in here? My lord, what we are saying this, that the calculation that was given.
Whatever may be. This is something which the appellate authority made a mistake. But this is in final.
Yes, my lord. May I just.
You cannot override that.
My lord,
Then from tomorrow onwards, Mr. Sharma or all the councils of the electricity department should say that we are not going to hear what the appeal is. So don't come up with that proposition. That appeal is the remedy. All repetitions will lie.
My lord, may I just submit here?
Make that submission.
May I just submit here? My lord, what am I submitting is this, that the appeal order correctly said that there was tampering of the meter and there was a malpractice. The moment, my lord, the malpractice comes into action, my lord, 4.2.2 will not come into effect. Whatever the, my lord,
All things are understand.
my lord.
I
So,
understand.
my lord,
No, I understand.
there is a
But no,
bonafide
no,
error,
no, no. But without this order being challenged
my lord.
by you, how can you do this?
My lord, that is where I'm coming to, my lord. If, my lord, the moment the 4.2.2 is not applicable, the 5.8.4 will come in. And being a bona fide error, my lord, because the consumption of
So
electricity,
error is whose?
error is us,
No, you see, the error was of the appellate authority.
my lord.
So when it is the error of the appellate authority without correction of this, without seeking rectification of this order, how can you now come up with
Yes.
another thing?
May I just submit on that point only? My lord, the Prem Cortex judgment had clearly stated that if there's a bona fide error on calculation of the mistake, then the right of reissuing of a bill still exists. So,
Till any time.
my lord, this is a judgment, my lord. It elaborated 56.2, my lord,
What is that?
2021-20 SEC. 56.2, my lord. May I just
Yes.
take it from paragraph 20, my lord? As per my understanding, my lord, before, my lord,
Careful reading of section 56(2) would show that the bar contained therein is not merely with respect to disconnection of supply, but also with respect to recovery. If subsection 2 of AI is dissected into two parts, it will read that no sum from an AI under this section shall be recovered after a period of 2 years from the date on which such sum became first due. The license shall not cut the electricity. Therefore, the bar actually operates on two distinct rights of the licensee, namely the right to recover and the right to disconnect. Bar which reference to the enforcement of the right to disconnect is actually an exception to the law of limitation. It extinguishes remedy, the remedy in not to be precise, but is extinguished by the law of limitation. This is not a case of mistake or bona fide
My
error.
lord, this there's another judgment. And my lord, my case is absolutely a bona fide mistake.
No,
Because
no,
the
it is,
calculation.
no, it is not a bona fide mistake. I'm telling you. This is a mistake committed by the appellate authority. And the mistake why the appellate authority did it is because, therefore, you see, I was therefore thinking, why for 84 days? It is 1 crore 41 lakhs. Whereas for 16 months, it was 1 crore 59 lakhs. The difference is because when you first made the assessment, where you came, then you came up with a particular figure, minus it with the amount which you have already taken, and multiplied it into 2, and which came to this particular amount. This is how you did it. And against that, when he filed the appeal, the appellate authority adopted the same formula and directed you to do it in that manner. Accordingly, you did it. This aspect was caught by the audit. And the audit said that, look here, this is not wrong. This is wrong, taking into account that this is a case of malpractice or tampering with the meter. So it should have been, these 84 days should have been calculated in terms with 5.8.4.4. So you now, after 2 years, almost 1.5 years, take up this issue for additional demand, and then you issue a notice to him. As per Prem Codex, you can ask for that, but not in exercise of 56(2)
My lord,
after 2 years.
no, but Rahmatullah Khan, the judgment which I've given thereafter, in a bona fide error, my limitation is not there, my lord.
Huh?
Yes, my lord, the Rahmatullah Khan, the judgment which I've referred thereafter.
No, Rahmatullah Khan was distinguished.
My lord, KC Nanin was there.
And you see, Rahmatullah Khan is in respect of this consumer forum.
No, Ajmer Bidyut, my lord,
Rahmatullah
issue-
Khan's case was that these people, after certain period, they went, but the court
my
at
lord.
the last one
lord.
said,
At para 657, my lord.
Page?
Page 657, the period of limitation of 2 years would commence from the date
para,
of
para,
para 7.5, my lord.
period of limitation of 2 years
Years
would
would commence from the date on which the
yes.
electricity charges become first due under
First
subsection.
due is the date on which the bill is issued.
Yes. First due under subsection 2. The provision restricts the right of licensing company to disconnect electricity supply due to non-payment of dues by the consumer unless such sum has been shown continuously to be recoverable as area of electricity supply in the bill raised for the past period. If the licensing company were to be allowed to disconnect the city after the expiry of the limitation period of 2 years, after the sum, it would defeat the object of 56(2). Section 56, however, does not preclude the license company from raising a supplementary demand after the expiry of limitation of 2 years. It only restricts the right of licensee to disconnect electricity supply due to non-payment of dues after the period of limitation of 2 years has expired. Nor does it restrict other modes of recovery which may be initiated by the license company for recovery of supplementary demand. Applying the aforesaid ratio to the facts of the present case, the licensing company raised an additional demand on 18/3/2014 for the period of July 2009 to September 2011. The licensing company discovered the mistake of billing under the wrong tariff code on 18/3/2014. The limitation of 2 years in the subsection section 56(2) had by then already expired. Subsection 56(2) did not preclude the licensing company from raising an additional supplementary demand after the expiration of limitation under 56(2). In the case of mistake or bona fide error, it did not, however, empower the license company to take recourse of the coercive measure of disconnection of supply for recovery of the additional demand. As per section 17(1)(c), then the limitation part which my lord is talking about. In the present case, the period of limitation would commence on the date of recovery of the mistake. The licensing company may take recourse of any remedy available.
No, Mr. Sharma,
Hello.
all things are understood.
Hello.
But here the mistake is by the appellate or in the appellate order.
Hello.
What you are trying now, on the basis of the audit objection, to overrule the appellate's order. Problem arises there.
May I just rephrase it in a different way if my lord allows. My lord, this is not an unjust enrichment here. The electricity has
I'm
been,
not concerned with unjust
Yes, yes.
enrichment. We are on law.
yes, my lord.
The law categorically says that the appellate order was passed.
Yes, my lord.
Appellate order category. Therefore, I'm saying this last part of the appellate order makes it very clear. Here says the assessed period should be so and so, and the average per day consumption should be calculated from so and so as per submitted by so and so. So that person submitted. And using the formula 2 into average consumption per day into 84 days prevailing rate during the assessment period. So this, and if the new penalty, so this is the calculation which is being provided. And in terms of the calculation, you did it.
My lord.
Now, what was required to be done as per you was in terms with 5.8.4.4.
Yeah, my lord, the moment the appeal passed the order, we did it as per the order of the appeal,
Ah.
our first bill.
Ah.
And then the audit directed us,
All understood.
My
So
lord.
therefore, can you allow the assessing officer on the basis of instructions issued by the audit to change the appellate order which you and they both are bound? My question is that.
my lord, order of I understood my question, my lord. My lord is saying that we are handcuffed now because of the appellate order, because the appellate order has given a direction. Agreed, my lord. But the order of the appellate only gave us the formula. And that formula we took into the direction. But thereafter, my lord, the process, the billing, the first bill, if you would have raised without following the order of the appellate,
Then it could have done it as per 5.8.4.
My
You
lord.
could have.
my
But
lord,
what happened? The mistake is again you come back to the appellate order.
my lord, because that order has attained a finality. The moment the order has attained finality, my lord, we served him the bill, and then the bill was scrutinized by the audit. So, moment there was an scrutinized by the audit, my lord, the bill becomes a supplementary additional bill to the bill which was given by the
No. Where is that supplementary
My lord.
additional bill?
my lord. In a way, what I'm trying to submit
You
is this.
cannot. I understand what you are saying. You say that your right to claim additional amounts continues in view of these two judgments.
My lord.
So therefore, you are saying that even if we have given the final bill, but if it was wrongly done, the final bill was wrongly calculated, that my right to claim additional amounts still continues.
My lord.
That is your
My
submission.
lord.
But the question is, you cannot. Yeah, because that period has already come to an end. Because if you go as per the formula given by the appellate authority, you cannot exceed what has been given in this.
I absolutely agree with you, my lord, but we have not exceeded the time period.
I'm not on that. Unless you set aside this order, get this order of the appellate authority set aside. How do you do it? There the problem arises. You again, because what happened most probably in the appellate order, the appellate authority was more concerned with the period.
My lord.
Because must have been submitting that, look here, how can it be done for so many days? The appellate authority says, okay, let's get away with that. And gave it okay only for 84 days. But there was a mistake in the initial calculation in which the judicial authorities were not aware of. And thereby, the appellate authority should have only restricted to these 84 days and do not say, and should have directed that it should be done in accordance with law. But what happened, the appellate authority said to apply the formula on which you applied earlier
My lord.
and ask you to do it. Now, in that process, you do it and you come as per Annex 15. And the problem arises later on this is.
My lord, this was the submission I had.
I know what is your great submission.
Lordship, one thing I like to point out that actually there is. no
Don't
smell-
spoil your case. Are you going to spoil your case?
Oh, there's one more
The one submission,
argument that
Lordship.
I would like.
Only one
Okay,
submission,
make
Lordship.
submission.
When the audit objection came to the knowledge of the respondent, why they did not file a review petition before the appellate authority Or why did not change the judgment passed by the appellate authority? What will happen to the hierarchy of the, let's say, the judicial, quasi-judicial authority?
Hello.
Okay, taking your submission, we give him the liberty to file a rectification
Mal-
application. We give him the liberty to file a rectification of the
Definitely.
appellate order.
My lord.
Heard Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner. Mr. S.P. Sharma
Mal-
appears on behalf of the respondent. The petitioner herein is aggrieved by the issuance of a show cause notice and the issuance of a bill bearing number 119 dated 25/7/2017 for rupees 1,22,45,649 and the order dated 30/11/2017 on the ground that the respondent concerned respondent authorities, more particularly the respondent number who did it?
Five, respondent five.
The respondent number
Area
5
manager.
could not have. The respondent author on the ground that the respondent authorities could not have exercised, have exercised their authority illegally and beyond the directions passed by the learned appellate authority in the order dated
Sorry, it will be respondent number 6, not 5.
in the order dated 5/1/2016 in appeal number 36/2015. Full stop. To appreciate the grievances of the petitioner, it would be seen the grievance of the petitioner, comma, it would be relevant to take note of the brief facts which led to the filing of the present proceedings. The record reveals that pursuant to inspection
Yes, ma'am.
inspection being carried out and provisional assessment bill was prepared in terms with section 126 of the Electricity Act 2003, hereinafter referred to as the Act. Full stop. In terms as per the said provisional assessment bill, comma, an amount of rupees 1,59,39,930 was the amount assessed that the petitioner was liable to pay to the respondent authorities. It is very pertinent to mention that in the said provisional assessment bill, as well as the remarks so put in the said of provisional assessment bill, it was mentioned that there was tempering of the meter. The petitioner being aggrieved preferred an appeal against the said provisional assessment bill. Full stop. While the said appeal was pending, the final assessment bill was made. Thereby, finalizing the the assessment made in the provisional assessment bill. And there was a demand made of an amount of rupees 159,39,930. At this stage, it is very pertinent to mention that a perusal of the said assessments so made of the petitioner for the period from 1/3/2013 to 36/2014, and on the basis of which the amount of rupees 1,59,39,913.18 was arrived at, would show that the period in question was taken from 1/3/2013 to 36/2014. Further to that, the method, further to that, the calculation so made was taken into consideration the average units for the period from for the said period at 4,835 units per day. Full stop. And the said average consumption was taken on the basis of the consumer's average maximum consumption during the period from 1/1/2012 to 33/2012, prior to the meter cover open tempering recorded in the meter. Full stop. It is further seen that the amount of rupees 1,59,33, 1,59,39,930.18 was arrived at by subtracting the amount what the petitioner paid during the said period from 1/3/2013 to 36/2014 from the amounts so arrived at by taking into account the average maximum consumption of 4,835 units per day and multiplying the same with the factor 2. The record further reveals that the petitioner being aggrieved by the final assessment bill preferred an appeal before the appellate authority in terms with section 127 of the Act. In the said proceedings, the petitioner filed an application for waiving the 50% deposit. Full. The said application was not taken into consideration, which led to the petitioner filing an writ petition before this court, which was registered and numbered as WPC number 6807/2014. The record further reveals that by an order dated 9/1/2015, the writ petition being WPC number 6807/2014 was disposed of, thereby directing the petitioner to deposit an amount of rupees 20 lakhs by way of a bank draft within 3 days from the date of the said order. And there was a direction upon the respondent authorities to restore the electricity supply. In addition to that, the petitioner was given a period of 6 months to deposit the 50% of the demand so made in the final assessment bill dated 19/11/2014. And thereupon directed the appellate authority to take up the said appeal and decide the same within a period of 3 months. Full stop. The record reveals that the appellate authority decided the appeal by an order dated 5/1/2016. Full stop. The appeal was registered as appeal number 36/2015. In the findings so arrived at by the learned appellate authority, it was opined that there was malpractice committed by the petitioner. However, it was observed that the amount of penalty billed was not correct, as there was no malpractice till 10/4/2014. And accordingly, the AGM IRCA was asked to correct the bill in the manner provided therein. Full stop. The relevant portion of the order passed by the learned appellate authority is being relevant. The relevant portion of the order passed by the appellate authority, as it has relevance, great relevance, has seminal relevance to the instant dispute, is reproduced herein under page 17 after hearing of a future bill of the party লেখে ঠিক আছে page 17 মই একটা রিন করি মার্ক করছি আমার ইয়েলো বো নাই নি ও আছে Mr. Sharma, you could not help by yourself with your arguments, but taking it that both of you you start your name with an SP, the other SP Roy has helped you out with giving you that handle. From the above quoted portion of the learned appellate authority's order dated 5/1/2016 shows that there was a specific direction in which the bill was required to be prepared, meaning thereby that the assessing authority was to calculate the average per day consumption from 1/7/2014 to 30/11/2014. And the assessed period should be from 10/4/2014 to 4/7/2014 only, bracket 84 days. It was further mentioned that using that said formula, comma, then it is further mentioned that the formula to be used is 2 into average consumption per day into 84 days into prevailing rate during the assessed period. Footnote. On the basis of the said directions so passed on 5/1/2016 by the appellate authority, the assessing officer made the final assessment and arrived at a figure of rupees 21,67,221. And further observed that as the petitioner had already deposited the amount of rupees 79,69,965, the amount to which the 965, the future bills of the petitioner would be adjusted against the amount of rupees 58,02,744. The record reveals that almost after 1.5 years from the date of preparation of the final assessment amount in terms with the directions passed by the appellate authority dated 5/1/2016, a notice was issued by the area manager IRCA-Roman 2 APDCL bracket LAR stating inter alia that in view of the audit objection, the earlier bill of the petitioner has been revised and served to the petitioner for payment within due date. Footnote. It is pertinent to mention that no notice whatsoever was issued prior to doing so. Footnote. It was found that the petitioner, as per a new calculation carried out in terms with clause 5.A.4.4 of the Electricity Supply Code and Related Matters Regulations 2004, bracket, regulations of 2004, the petitioner was assessed to rupees 1,44,13,170.44 for the period from 10/4/2014 to 4/7/2014, that is 86 days. And as the petitioner had already paid the amount of rupees 21,67,221, the petitioner was directed to pay a further amount of rupees 1,22,459.45949. Footnote. The petitioner thereupon being aggrieved submitted an application to the area manager, IRCA-Roman 2 APDCL bracket LAR, for withdrawing said amount by the communication dated, no dates, 28/7/2021, 17. Full stop. The same having not been considered, and on the other hand, there was a direction. Listen, and the same was, however, rejected by an order dated 9/8/2017 by the area manager IRCA-Roman 2 APDCL LAR. His response number 5. 5, na? 5 or 6?
5, my lord. Area
5.
manager,
It is
IRC.
5. 5 koi diba, ha?
Area manager is 5.
File over. The petitioner filed a writ petition before this court, which was registered and numbered as WPC number 4983/2017. The record reveals that the said writ petition was disposed of by an order dated 21/8/2017, thereby directing the respondent authority, the petitioner, to file a fresh representation within a period of 3 days before the respondent number 5, agitating the issues raised in the writ petition, and further directing the said respondent number 5 to dispose of the said representation by giving a proper opportunity of hearing to the petitioners. Full stop. It was also further observed that, taking into account that the respondent authorities have been slapped with a heavy demand after a period of 2 years, the respondent authorities were directed to consider as to whether any further relaxation can be made in favor of the petitioner. Full stop. The relevant portion of the order passed by this court in the of the order dated 21/8/2017, being pertinent to the instant dispute, is reproduced herein under. Be that as it may, writ petition stands disposed of, page 99 of the yellow koi diso number 2 B2 yellow disposal material. The petitioner thereupon submitted a representation before the respondent number 5 on 24/8/2017, and the said representation was rejected by an order dated 30/11/2017 by the respondent number 5, and it is under such circumstances the present writ petition has been filed. The record reveals that by an order dated 21/12/2017, this court, while issuing notice, directed the respondent authorities not to take any coercive action against the petitioner, subject to petitioner depositing an amount of rupees 50 lakhs. Full stop. It has been submitted by Mr. S.P. Roy, the learned counsel, appearing on behalf of the petitioner, that the petitioner, on the basis of the order dated 21/12/2017, had deposited the further amount of rupees 50 lakhs. The record reveals that the respondents had filed the affidavit in opposition full stop. The basic crux of the stand so taken by the respondents in the affidavit is in tune with the order dated 30/11/2017, mentioning that the respondent authority had the assessing officer, while making calculation of the amount, in respect to the final assessment bill dated 21/3/2016, had applied the wrong provision in as much as clause 4.2.2.4 was applied, which was only for regular billing, whereas the billing, the proper mode which should have been applied, the proper provision which should have been applied is 5.4.84, 5.8, capital A.4.4 of the supply code, in as much as there was a finding of fact arrived at by the learned appellate authority to the effect that there was tampering of the meter and there was apparent malpractice committed by the petitioner. It was therefore submitted that as a wrong provision was applied, the same was corrected by the impugned reassessment bill dated 25/7/2017, and accordingly the amount of rupees 1,22,45,949 was arrived at after taking into consideration that the petitioner had deposited an amount of rupees 21,67,221. Footstep. That's your stand, huh? Nothing more. The report further reveals that an affidavit in reply has been filed by the respondent authority, a petitioner, wherein the very wherein apart from reiterating the statements made in the writ petition, question the authority of the deponent who filed the affidavit in opposition on behalf of the respondents. In the backdrop of the pleadings, I have heard the learned counsels appearing on behalf of the petitioners and have given my anxious consideration. The record reveals that from the pleadings and the materials on record, it appears that in terms with the crux of the matter appears that the petitioner is here, that the respondent herein, who is the assessing respondent hearings, and more particularly the respondent number 5, who is the assessing officer, is bound by the order passed by the learned appellate authority dated 5/1/2016. And the assessment, and the assessment had to be carried out in terms with the directions passed therein. The learned counsel appearing on behalf of, though Mr. S.P. Sharma, the learned counsel appearing on behalf of the petitioner, the respondents submitted that taking into account the findings which have been arrived at by the learned first appellate authority, upon inspection, taking into account the findings of facts as arrived at while inspection, as well as the order dated 5/1/2016, it is clear that there was a case of tampering with the meter and would be a malpractice within the ambit of, within the meaning of, within the ambit of. Where is that you have given me something, na malpractice somewhere? Oh, yes, yes. Within the ambit of clause 5.A.3.1 and 5.A.3.2. Full stop. The Land Council submitted that as there is a tempering of the meter, comma, it would come within the ambit of theft of electricity as detailed under section 135 of the Act. And therefore, the said, and therefore the assessment was required to be made in terms with clause 5.A.4.4. Wherein the formula have been stipulated as to the manner in which the calculation is required to be made. First, this court appreciates the said submission, but the respondent authorities, and more particularly the respondent number 5, have completely forgotten to take note of that the appellate authority is a creation of the Act, and the orders so passed by the appellate court, appellate authority, is binding upon the assessing authority. First, the appellate authority had categorically mentioned the manner in which the calculation was required to be made. First, it further reveals from a perusal of Annexure 15 and 16 of the writ petition, which is the final bill prepared on 21/3/2016, that the assessing authority, that is the respondent number 5, have carried out the assessment, the final assessment, in terms with the directions passed by the learned appellate authority, dated 5/1/2016. First, under such circumstances, without there being any rectification to the order passed by the learned appellate authority, or to the order passed to the order dated 5/1/2016 of the appellate authority, comma, the respondent number 5, even on the basis of an audit objection, could not have altered the formula as it would amount to overreaching the order passed by the appellate authority. First, it is seen, however, that the respondent number 5, on the basis of the audit objection, had passed the order dated have passed the revised assessment bill, have issued the revised assessment bill on 25/7/2017, and have further rejected the representation by the order dated 30/11/2017. Under such circumstances, this court therefore is of the opinion that the impugned revised assessment bill dated 25/7/2017, as well as the order dated 30/11/2017, is not in accordance with law and requires to be interfered with. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the order dated the revised assessment bill dated 25/7/2017, issued by the respondent number 5, directing the petitioner to deposit an amount of rupees 1,22,459,45949 is interfered with, is set aside and interfered with. Number two, the impugned order dated 30/11/2017, being contrary to the order passed by the appellate authority dated 5/1/2016, is set aside and quashed, is interfered with and set aside and quashed. Full stop. Number three, this court, however, full stop. Number three, any amount deposited by the petitioner pursuant to orders passed by this court has to be adjusted against the future bills of the petitioner. Full stop. Number four, comma. This court, however, observes that in the circumstance the respondent authorities seeks any rectification of the order dated 5/1/2016 before the appellate authority, comma, and if there is any further rectification being carried out, it shall not be a bar on the part of the respondent authorities to go ahead to make fresh assessment in respect to the period concerned. Full stop. This court further takes note of that in view of the pendency of the instant proceedings and bona fide believing that the petitioner is in the position, the respondents were in the position to apply the provisions, apply the clause 5.A.4.4 of the code, comma, there was no rectification sought for to the order dated 5/1/2016 by the respondent authorities. First, the said respondent authorities, the period, accordingly, the period from 25/7/2017 till date be excluded while computing the period of limitation, if so, any, for filing any application seeking review of the order dated 5/1/2016. This is because of Mr. Roy. He came. He helped.
Sir, it is a public money.
No, I think with that, you can get it done. Yes.
If they up to the instruction, the fact is clear that that work has been done, that amount is due and it has not been paid.
And?
That it has not been paid as on the instruction, 2019, that amount has not been paid.
So pay within 3 months,
Lots, examine and paid by the commission.
verify and pay.
Lots.
Some orders are not. Verify and pay. From the date of certified copy being submitted to whom?
The commission.
Commissioner?
Yes.
The other line लिखी हुई है, Mr. So-and-so submits that the work has been duly completed and the payment has not been done on account of non-hand have been duly completed as per his instruction. How much the petitioner is entitled to can only be ascertained after due verification. Statement is that. Yes, what is this?
They had to deposit KISS money of a certain amount, madam. They are contending that during that period, because of COVID, they could not operate. So they might not file the first round of writ petition saying that their prayer should be considered for waiving of that period of KISS money. But my lord, through this speaking order, which is under challenge, that prayer was rejected. Reasons were that, my lord, during pandemic, there was no hindrance for operating mines. In the very first notification, it was said that all mines can operate and all transportation for mines will continue unhindered. And my
How will the people go to the mines?
during that time,
During that time,
Yes.
no person was allowed to move from here to there.
yes, ma'am. But all mining related activities,
They were allowed.
yes, ma'am. Anybody who's working with the mines, they were allowed, my lord. Just like construction, my lord, construction was going on.
Construction of what?
Uh, Wherever, my lord, public constructions were going on, my lord, those were not.
Show me, where is the notification?
If your lordship comes to the speaking order in page 79 of the writ petition, my lord. In
Yes.
findings, point 1, this is the notification.
This is by the home.
Yes.
But what about the others? Your state.
This was made applicable all over India. This was the first lockdowns notification.
No, this was the first one.
Yes.
What about the other ones?
Others, I'll get, if, I'll ask for detail.
Hmm? Is some other judgment?
This one, first round of litigation where they sought
No,
consideration.
extension of the secondary does not arise and is not entitled to the however the basin can to be value presentation for remission of the fees money along with further prayer to set out the remaining. Where are those notifications by which a person? This is there. It is allowed now coal production, mines and mineral production, their transportation, supply of explosive and activities incidental to mining.
Settle with the other party. So
Huh?
only settle with the other party. So later it becomes
Infructuous. No, you don't want money.
they settle with the other party. So
You have none. Oh, Mr. Botago.
Yes.
He once says that she doesn't want to press.
Then
Very good.
Yes.
Your name?
I have
You are there in the, yeah?
on behalf
You are not there. Have you filed the wakalatnama? signed the wakalatnama? You? There are only two persons who signed the wakalatnama, A. Y. Chaudhary and T. A. Chaudhary. No behalf of, because you are making a very important submission. Tomorrow the petitioner will come up and say that who is she? Get hold of them. Where are those? A. Y. Chaudhary and T. A. Chaudhary? Huh?
The praying namaz, Juma namaz.
No, I can't on the basis of your prayer close it. Sorry. If I do it tomorrow, it will become a huge issue. You dismiss for default. None appears for the petition. None appears on behalf of the petitioner on call. Mr. Aibot Thakur appears on behalf of the respondent. It is seen that on the earlier occasion also the petitioner did not participate in appear in the matter. So it appears that the petitioner have lost interest in the matter for which the petition stands dismissed from all.
My lord, one preliminary objection was there, that whether the petitioner is eligible to file this writ petition because a partnership firm, my lord, submitted the tender.
Tender, what has happened?
Tender, my lord, technically we qualify, but only one thing. That,
No, what has happened to the tender? These are 2022.
Yes,
There is, the work was allotted in the year 2022 itself.
Then,
And Lordship on last day directed us to furnish the progress of the work, Lordship.
period of the work,
It is supposed to be, it is, by the 18th July 2026 is the completion,
18th,
July 2026.
26.
So that is the certificate. If Lordship comes to the last paragraph, Lordship, of the first page. Yes, Lord.
Aligned with an email, the project employs zero residue technology model and awarded on tender at a cost of with a processing capacity of approximately 2,000
So out of 10.85 lakh, Lordship, we have already removed 7.24.
So as of now, it is to be completed when?
Last but one paragraph, Lordship. Sigma Global Environment Solution Private
Manage
Limited
the
was
remaining
commissioned to
waste with
manage the
project
remaining way
scheduled for
waste
completion. by-
with the project scheduled for completion by 18 July 2020.
Mr. Gurgami, what is there now in this case? You should have
There
either
should have-
got a stay there. Nothing remains.
They should have filed this affidavit way back in the, my lord, 2 years back at least. So that I could have, my lord, filed addition, reply, my lord.
And not only reply, they have not filed, that's a different thing, but the question is, does it make any sense now?
Now.
When it is almost a
I
luck
understand. That's why my petitioner also, this party also not interested. Because they,
We close it as not interest,
no, my lord, that's why, that cannot be
Then
because.
then
they
what
have
should I
been
do?
like- They have not given anything.
No,
I
it's
told them
okay.
to give me at least so that I can withdraw if necessary. But in writing, they have not given anything. So otherwise, your lordship as your lordship pass any order. Otherwise. Because they are at page 61, that note that Jan Adhar Sebhavani is a trust. Well, that's why we were disqualified. It's not a fact, my lord. It's not correct.
We keep the question open. Keep the question open
Yes.
in future. But I think we close this petition unnecessary. The petitioner herein heard Mr. R. Goswami, the learned counsel appearing on behalf of the petitioner, and Mr. P. Nayak, the learned counsel appearing on behalf of the respondents,
2 and 3, yes.
2 and 3. The issue involved in the present proceedings is as to whether the petitioner is a joint venture whether the
61, page 61,
petitioner,
last note, below.
as to whether the petitioner herein. Page,
Page 61, last note below. At the bottom,
which one? Page 51, which one?
61.
61.
yes. At the bottom below, it is a bidder should either be a company incorporated under the Companies Act or under the applicable laws origin or a partnership firm or a limited liability partnership or a proprietorship or any combination of them with a formal intent to enter into joint bidding agreement or under an existing agreement to form a joint venture consortium. But JV partner, Jana Adhar Sabhavani is a trust. That's why, my lord, they have rejected our tender.
The JV partner
Yes,
is a trust.
trust,
No, this is your rejection.
rejection.
Now, who is the JV?
Jana Adhar Sabhavani, my lord, they have.
No, no,
authorized-
how can Sagar Motors be
Yes,
a?
in fact, that is my ground, lordship. The bidder is not before your lord.
Then,
One of
My
the
lord, this is
partner
the
is.
letter,
before
my
your
lord.
lord.
no, no,
Authorized
how
us
can the JV should have come before the court?
Should have come, but they
Then-
have given authority. my
No,
lord. Lord,
no,
they
no,
can
no,
pay-
no. These authorities they cannot help. He has to come.
No, they have said that
Now, then it has to be by way of a power of attorney. The petitioner has to be the JV.
both, my lord, because
No,
joint
the
venture
petitioner has to be the JV
and
and,
Sagar Motors.
and thereby supported by the other two, the constituents of the JV. I pass one judgment on JV business. What was
But-
the name?
Lordship, in
No,
2021,
no, dismiss করবে লাগে। আর the petitioner herein have assailed the rejection of the bid submitted by
partnership firm, my lord.
submitted by whom?
This Sagar Motor and this
No, no.
Janadhar. Both are
What is the name of the bid the petitioner who submitted?
the tender,
Your JV has to have a name.
yes,
Where's the name?
Page 59, lordship. Page 59, last column, top
Last?
column. JV Motors and Jana Adhar Seva Bhava.
It is half, it has come back. JV origin, so and so. JV.
Last one. Sagar Motors and Jana Adhar Sabha.
And John Adhar. No, what is the
Devapani.
name you don't know?
Devapani.
What is your name? Who submitted? It is not mentioned anywhere. Where is the formation of the year?
No, these
Joint
are
venture.
bidders, lordship. Page
No,
59.
that is not known. The petitioner herein have challenged the rejection of the bid by a joint venture consisting of the petitioner and another on the ground that the petitioner's partner, the petitioner's partner with whom the petitioner formed the joint venture was a trust. Full stop. It is relevant to take note of that the petitioner, the joint venture is not a part, is not the petitioner in the present proceedings. Full stop. Further to that, a perusal of the entire pleadings would show that there is no mention as to what joint venture was formed. Considering the same, comma, in the opinion of this court that the petitioner alone do not have the local standing to challenge the rejection of the bids so submitted by the joint venture in absence of the joint venture being a party to the proceedings. So considering the above, the instant petition stands dismissed. Will cost?
No, my lord,
No, we should cost.
authority letter was there.
Authority, no. What? You don't know what is the name of the firm? Yes.
My lord, they have no interest at all because
No,
the contract was given to other party, my lord.
uh,
No affidavit was filed.
Arietta Langley, in addition to that, this court also, in public interest, would not like to interfere with the instant proceedings, taking into account that the work have already been started pursuant to the work order issued, and it is to be completed by July 2026. Accordingly, the writ petition stands dismissed.
Like,
Non-payment, verify, pay within 3 months. Hey, do, hey, no, no. You appear as additional AG.
Here, PWD.
Additional AG appears out here and so. We said the work has been done, but the which
is not there, madam.
will verify.
Without instruction, I cannot admit the amount.
I'm not asking you. The work has been completed, but the question as to whether the petitioner is entitled to the said amount or not would be subject to verification. The shall verify and pay. PWD.
PWD.
So then it will go as per Tamsir Ali.
Right.
Go as per, itu Tamsir Ali to look at.
Otherwise, completion certificate here.
Yeah, Tamsir, and accordingly, comma, the respondent authorities are directed to make necessary verification as regards the entitlement of the petitioner, and thereupon apply the ratio as laid down by the full bench of this court in Tamsir Ali versus so-and-so, reported in so-and-so, and make payment in accordance therewith. আগৰ লিখি দিব দেই। Yes, non-payment. Admitted.
Filing it. I'm filing it.
Are you admitting it?
Admitted, madam.
Okay, verify and pay.
The similar matter already fixed. Similar matter already fixed on 31. Same petitioner, same advocate. Next.
So what?
I'm filing it.
Verify and pay. Within 3 months.
As per
According
Tamsir Ali,
to-
madam.
Huh?
As per Tamsir Ali. As per Tamsir Ali.
No, as per Tamsir Ali. You are no business of Tamsir Ali. What is this
Yes.
government
TAC department.
department?
TAC, Public Health Department, Public Health Engineering, Public Health Engineering.
Irrigation, that is not Tamsir Ali. Verify, pay within 6 months. Tamsir Ali is only PWD. And which period?
Amount. Amount is, we had completed the work on is page 35. By 21, we have completed, 21.
2021.
But thereafter, the approval has been sent to the secretary for sanctioning the amount. Ultimately, the secretary of BTC has approved the amount.
To verify and pay within 6 months. আমার order আছে। Non-payment.
Process of payment is under process.
Huh?
Process of payment is under process. time will be required. Lordship.
Okay. Ms. G. Bora, the learned counsel appearing on behalf of the respondent, Agriculture Department submits that the petitioners claims are under active consideration of the respondent authorities. And within some time, the said payment would be made. Full stop. In that regard, she has placed before this court an instruction which is kept on record and marked with the letter X. Taking into account the above, lists this matter on 18th of August 2025, on which date Ms. G. Bora, the learned counsel appearing on behalf of the Agricultural Department, shall apprise as to whether the amount have been disbursed to the petitioner. We'll have it in the month of September, 8th of September.
Seek the instruction, my lord. We have not received, my lord, till date.
No instructions? Hello, which department?
So during the election, state election commission is also part.
Yes, madam. They entitled to the amount or not?
It was a work order issued by the district election officer. So we would need, we would need, we have asked them for their information, but we have not received any information from them. What has happened?
Chalo, we'll
exactly
have, we'll see the chief electoral officer out here before this court. If he has not informed you, nothing is there. No chance.
Wait, please, your lordship, actually, we have, whatever money is normally required, your lordship, we sanction it and we send it to the district election officer. And thereafter the district.
I'm asking you whether the petitioner is entitled to the amount or not.
Your lordship, I would need, actually, it is only the district election officer who will be able to answer this question because we directly do not deal with the parties, your lordship.
So this is panchayat.
It is for the parliamentary elections, your lordship.
Is this for the parliamentary or the panchayat?
It's a parliamentary.
Then
election,
you are
lordship.
bound.
Your lordship, then kindly give me one week's time to get my instructions. 1 week's time, your
The
lordship.
petitioner herein have claimed an amount of rupees 9,57,275 as the dues to which the petitioner is entitled to on account of CD conversation in connection with the parliamentary election 2024. The record reveals that in the month of September 2024, notice has been issued. However, the Standing Council of the Election Commission of India, who represents the Chief Electoral Officer, Assam, as well as the government, state of Assam, is unaware of have no instructions in that regard, taking into account the above, this matter again on 4th of August 2025, on 8th of August 2025, on that day, both the councils appearing on behalf of the Election Commission of India as well as the state of Assam shall apprise this court as to whether the petitioner is entitled to the said amount, so claim, and if so, when and how the said amount would be paid.
Same matter. Same matter.
All right.
Yes, another petition is pending, then 2729 of 24.
Yes, Pisari.
One interesting thing, against Badgaon Hayapara, there is another petition pending in the AFDC related matter. Against this Badgaon Hayapara Samavai Samiti, this was represented by Joydev Das. Against him, all the 9 board of directors has filed a petition. Saying that he has no authority to file any, represent the society. And he is giving bid without authority. This Badgaon Hayapara.
Not the matter.
So let this, that matter also may be tagged on.
Maybe. It is.
684 to all the matters, Lord.
Which are the, which item?
Item 11 and 12.
Along with that, which one do you want?
Another one is WBC 84, 2025.
And why that has not been listed? 684. There is no order earlier passed?
No, no, it's actually, it is,
In Miller, who say, there is.
What are you challenging, Mr. Kotoki?
Challenging settlement order. That settlement order was put into challenge in 2729/24. No, that has not been listed along with this order. There was an order in 2729 to list along with the.
Settlement given in whose favor?
Settlement given in respondent number. Against, in favor of respondent number 4, in my case.
And what is Mr. Escound appearing?
I appeal for item number 11.
Okay, what is this?
Actual fisherman certificate was not submitted with the tender.
Why do you need the earlier, another petition?
actually here, my concern is that this Badgaon Fishery Nayapara Society Limited, who is represented by Joydev Das, has no authority to file this requisition also because it is another matter is pending against him also, against Badgaon Nayapara. This society,
Against this society?
society.
Why the society is not in operation?
society, that is the fact, that is the case. Society is not in operation. All the members are saying that Joydev Das is running independently, they are not aware of anything. So they came before your lordship.
Why, how do you know that all the members are saying?
Lordship, the fact is that.
Have you filed the affidavit?
No, lordship.
Why you are not filing the affidavit in stating all these things?
Lordship, I will file affidavit.
Don't come up with all these things. We'll impose some cost on the fishery department. Why you don't make these submissions out there on thin air? All the other members are saying.
No,
How do
lordship,
you know?
I will file in the affidavit.
You are asking some other records have to be brought in out there. No. If you are not, we are considering him. You on verbally, I'm not going to take.
Okay, in that case, I will
Yes,
file
sir.
affidavit. Let me give me some time.
How much? 1 week.
Or 10 days, lordship.
Mr. P. Sharma, appearing on behalf of the Fishery Department, submits that he requires 10 days for filing the affidavit in both the matters.
Lordship.
Both the matters.
Lordship.
To stop. List this matter again on 28/2025, the affidavits be filed by 11th of August 2025. To stop. The petitioners, if so advised, would be at liberty to file their reply within 7 days thereafter.
Would this matter taken up along with WBC number 2729 of 2020?
Why?
This is similar.
This is
The judicial order, madam. Same settlement order we are also telling. All the
Go
matters.
before the registry. Ask them to bring it together. How can I say that? Not necessary.
Similar matter.
This one, 2729,
Yes,
there's
yes.
already an order.
Yes,
There was an order.
Then
it has not been taken.
it will be taken. No, there's no direction. The court did not direct. A joint submission is made by the learned counsel for the party. The matter is required to be taken along with so and so. As the matter is ready, as the same is listed in admission after remand on the date so fixed. Nothing. Then
Can we take, lordship?
the councils appearing on behalf of all the parties have submits that that along with the instant writ petition WPC number 2729/2024 be also tagged along to stop taking into account the above, the registry that is directed to tag along with the present writ petition WPC number 2729/2024. You file your affidavit there also.
Stating that fact, lord. Setting the pending petition, lordship. Then only.
Here non-payment.
Amount is admitted, my lord.
Okay, disposed of. Which department?
Irrigation.
Okay, 6 months.
As per
6 months, no Tamser Ali. Tamser Ali does not come in. It is an admitted amount, so the question is, you say that will be admitted, so make the payment within 6 months from the date you have get the certified copy. Yes, Mr. Mohan.
Pleadings are complete in this matter, my lord. Pleadings are complete in this matter. Can this matter be fixed, my lord, for admission hearing on some other date, my lord?
What do you want?
Pleadings are complete, my lord, some other day, my lord, admission hearing.
Okay. Okay, it has been submitted by the learned counsel for the respondent, counsel, for the learned counsel for the respondent number
My lord, two.
2 6. Respond number 1.
One.
6 for an accommodation today. Full stop, list this matter on 8th of September 2025.
Deeply obliged.
Infraction?
Petitioner got the release.
Mr. A. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that as the petitioner's grievances have been redressed, nothing further remains in the instant proceedings. Taking into account the above, the petition stands closed as it has become infructuous. Mr. S. R. Burwa appears on behalf of the respondents.
May I please? TA S Neogi pending council QR number he is out of station.
Contractual bill, how much?
But here, 2 lakhs, my lord. In the first item number 16, my lord, total work order is for 10 lakhs.
What is your instruction?
Out of which,
My lord, I am praying on behalf of S Neogi, my lord. He is
S?
S Neogi. He is out of station, my lord.
What is Tiwa?
My lord.
you are, my lord.
Last time Tiwa, somebody come up and say that they admit and accordingly I made the direction. Anyways, the counsel appearing on behalf of the respondent. 6 for an accommodation. So stop. It is noticed that it is taken note of that on 21/10/2024, this court had issued notice seeking instructions as to whether the petitioner is entitled to the amount of rupees 2 lakhs as claimed in the instant writ petition.
Here, my lord, 4 lakhs.
4 lakhs as claimed in the instant writ petition. The respondents, however, have not filed an affidavit even after a passage of 9 months. Considering the above, list this matter again on 28/2025. Full stop. The respondents are directed to positively produce instructions before this court as to whether the petitioner is entitled to the amount, and if so, when and how the said amount will be paid.
17 of the same. 17 is also same.
208/2025. Huh?
17 is also same, madam.
Obliged.
4 lakhs. 17 is also 4 lakhs.
No, 2 lakhs.
Then what you are saying?
Sorry, madam.
Same,
Sorry, madam.
2 lakhs.
Obliged.
Boromari Economic Development Society.
Last time also nobody appeared on behalf of the petitioner, my lord. I'm appearing on behalf of the respondent number.
What is the matter about?
My lord, a matter.
No, there is no issue. It's to be decided is with regard to the stand taken by the petitioner, the listener could not have been selected as successful tenderer. Had not submitted the scheduled caste almost community certificate along with the attested photo. Yes.
I am paying for 2 weeks time to file our affidavit, my lord.
Then why you are not filing a affidavit? Notice was issued on 6/1/2025. Is it like this that in bench 4, it will keep on going? Huh? This is what I find.
That, my lord, I am the highest bidder.
Then
My lord,
Not the highest bidder,
settlement
sir.
has been given to the
Second highest.
private. Second
how many
highest.
years?
Well,
My lord,
just
7
years,
years.
7
7
years settlement.
Mr. A. Manaf, the learned counsel appearing on behalf of the petitioner submits that though the petitioner is the highest bidder, the settlement has been given to the private respondent.
I'm not, yeah, second highest, my lord.
Second
Second
highest.
highest.
The highest, second highest bidder, but the settlement has been awarded to a bidder who is far below the petitioner.
right.
Full stop. It is seen that by an order dated 6/1/2025, notice was issued, but but none of the respondents have filed their affidavit in opposition. Full stop. What about service upon respond number 7? Right. This court further takes note of that there is no record as to whether the service is complete insofar as the respond number 5 is, or 5 is here. So there is another one, nah? Oh, you have filed respond number 5.
I'm fine, madam.
And who appears for the government? Fishery Department?
Fishery Department, Fishery
P.
Department.
Sharma is there. Fishery Department is P. Sharma, nah?
Yeah, Fishery,
Yes, yes.
Sanjay Chowdhury.
It is seen. Well, এনেকে লেখো, huh? It has claimed he আগৰখিনি লিখি দিয়া, full stop. Mr. N.C. Das, the learned senior counsel, assisted by so-and-so, submits that within 2 weeks, the affidavit on behalf of the respondent number 5 would be filed. Full stop. It is further noticed that a fishery department is not represented when the matter is called. Full stop. The reason must be on account of the name of the standing counsel standing counsel, that is Mr. P. Sharma, being not reflected in the cause list. Full stop. The registry shall reflect the name of Mr. P. Sharma in the cause list as the SC Fishery Department. Full stop. List this matter again on 22/8/2025. Full stop. In the meantime, the affidavit in opposition be filed by 18th of August 2025.
Public life.
Lordship, in view of my physical appearance before the Honorable Supreme Court on 14th of this month, I could come to know only about the listing matter today only. So I come unprepared. So only 10 days adjournment is sufficient. for-
You are a petitioner?
Yes.
What do you want here?
No, I give adjournment 10 days adjournment because I have come to know only that matter is listed today. I was in Delhi for Supreme Court matter. I appeared down in court number 9. I cannot say 14th of this month.
So,
I could know only this morning because I was in Delhi. So I have coming here without any preparation.
Mr. Vatsali, you are a regular in the court, as I remember. All along there is one person who does a lot of matters by himself is you. So under such circumstances, for you, whether you subscribe to the list or not,
I was in Delhi. Lordship.
so what?
I
You
was-
are not in Delhi now.
No, I could come to know this morning. For other matter.
You came today in the morning. What am I going to do with that?
No, that matter was there in Supreme Court. I was there.
In connection with this matter?
No, other matter. So
How am I concerned?
no, therefore I could not come. Otherwise, I would have come on time. I would have come with all files. Therefore, please, only 10 days doesn't sufficient. Lord.
What is the matter?
It was lordship relating to settlement of tender, lordship. It is already over, lordship. He is not a participant in the tender process. Tender was given to some private person, lordship. He has completed the work. Nothing remains to adjudicate, lordship. In this matter.
In both the matters?
One metal work has been completed. Second metal, lordship, 65% of the work has been completed, lordship.
Hello, we'll have it after, when is the finishing of the other work?
Lordship, in fact, lordship, he could not finish the other work because the pendency of the case, lordship, the authorities are not releasing payment to him, lordship. This is the
So
issue.
now we need to finish it off. Okay, list this matter, Mr. P. Vatsarji appears in person. The petitioner appears in person and seeks for an accommodation. Mr. N. Upadhyay appears on behalf of
The official response, irrigation department.
Irrigation Department. Pusto. List this matter. And Mr. N. Upadhyay submits that in respect to one of the writ petition, submits that one of the writ petition has become infructuous, taking into account that the work has already been completed. In respect to the other writ petition, the work 65% have been completed and the remaining work is not, the contractor is not being able to do in view of the payment being held up on account of the pendency of the instant proceedings. Full stop. Taking into account the above, comma, list this matter again on 27th of August 2025. Full stop. An attempt shall be made to dispose of the petitions on the right.
All right. All right.
Non-payment of contractual dues, my lord.
PH, yes, what?
My lord, I am seeking some time, my lord, 1 week's time.
For what?
Usually, my lord, I don't appear in this case, my lord. With the petitioner, my lord, I have some conflict that is why I don't appear.
D. Kumar and Company.
R.R. Gogoi will appear.
Then I can't put your name. If you have difficulties, how do I put your name? Can I?
No.
So, none appears on behalf of the PHE department when the matter is called. Full stop. For the interest of justice, the matter stands adjourned to be listed again on 30 307-2025. Full stop. It is observed that if the PHE department is not represented on the next date, comma, the instant petition would be disposed of on the basis of the materials available on it.
That this IA has been filed. But in fact, the fine has been deposited, that cost part. Only thing is, my lord, the lordships kindly take a lenient view in the matter, my lord.
Which one?
This matter, my lord. Where, my lord, there was in the written statement which was annexed to the petition,
Yes.
there was some overwriting. and I think
No,
most of the lawyers.
Mr. Chaudhary, this is not the case. I'm telling you why I have done it. The manner in which they have done it, kindly see the
I've seen it, my
petition.
lord. I've seen it.
And this is something, and I'm only not blaming the petitioner council. I'm blaming here and there also.
Registry also.
No, there also.
Okay.
See my order.
Yeah, I've seen it, my lord.
See, before parting with the record, this court expresses its deep anguish in the manner in which the present petition is filed. The plain as well as the written statement are not at all legible, but only contain certain comments but only contains comments written in hand. The filing of the petition in this manner clearly shows lack of professionalism. Further to that, even the amendment application which was filed before the learned trial court did not contain what relief was sought for to be inserted. Mr. Chaudhary, you have to understand one thing. I allowed this only on the ground, because of those counsel of the plaintiff or plaintiff. You see, kindly see the amendment application.
I've seen it.
It does not normally in an amendment application you have to mention what amendment you are seeking.
At least within inverted comma.
Thing.
Very
Then in
casually
the
done.
petition also does not say anything. Nothing. Then also I allowed it. So I'll do one thing. I'll review this order and set aside this.
No, my lord. My humble submission
No,
is something should
Mr.
be there, my lord. Let them learn from their mistakes.
No, this is to learn as a deterrent I'm giving it.
I know.
Why I'm saying is, you see, it is relevant to observe that when a litigant approaches an advocate, it is his duty to do the
Correct.
needful to the best of his or their
Ability.
ability, and lack of diligence and professionalism is apparent on the part of the counsels of the petitioner before the learned trial court and before this court. As a matter of deterrent, this court imposes a cost of 25,000 upon the counsels appearing on behalf of the petitioner to be deposited before the registry of the. This court further directs that upon deposit of the said amount shall disburse it to the Legal Services Authority. Failing to deposit, they list the matter.
My lord,
No,
my
no.
humble submission is let a warning go, my lord.
No, this is a warning. This is a warning. This is required. Why it has been done? I'm telling you, the learned trial court was absolutely right in rejecting. I granted them.
I have seen it, my lord. Only thing is, my lord, if some lesser punishment or lesser observations could be made. That's what we
No,
want to
I'm
do.
not.
And we offer unconditional apology
No,
for the
no,
wrong.
no, Mr. Council. This is not how you do it. I'm not going to do. Mr. Chaudhary, I'm not going to do this. No, go to the Supreme Court.
The amount has already been deposited, Mr.
Good.
That we have not.
The amount has to be deposited, has been deposited. This is not. how
And
you
you'll
do it.
be careful in future, Miller.
And let's see this petition. See the
I've
application.
seen it.
Nothing.
Like in
You
respect
do,
of,
this is being done at the fag end. You see, I allowed it, making it as a subsequent course of action.
correct.
I'm not going to allow this.
The fact, my lord, the written statement where the handwritten note of the council is there. And how history passed it, I was wondering. Anyway, my lord, they realized their mistake. They have tendered unconditional apology, my lord. They're just seeking my lordship's, my lord, pardon. I leave it to lordship's, my lord. Only my prayer is, my lord, lordship will let, a message should go, my lord, that I am not on that. Only thing is, if some a view which is less lenient can be taken into that.
No, you are asking the plaint as well as the written statement are not only illegal, but also
No, it's
but also
my lord.
contains comments on the head. This is right.
Correct.
The filing of the very in this manner clearly shows lack of professionalism. It's true. It's relevant to observe that when a litigant approaches an advocate, it is the duty to do the needful to do the best of his or their ability, and lack of diligence is apparent on the part of the counsels of the prisoner before the learned trial court and before this court.
Sufficient. Lordships could take a lenient view in the matter. But that's the only thing. I'm not saying, I'm not trying to justify what was being done. It's a fact. It's a pure and simple act of unprofessionalism. Especially the written statement with all the written notes of the lawyer. It's already one. Lawsuit would like to have done some other day or something.
Illegal sale deed. That's how you do it. You want, I can do one thing. Along with these petitioners, we can also take it up with this registry. The stamp reporter who has said that the defect rectified.
Yes.
So we take it up with them also and ask them to that the High Court on the administrative side should initiate. penalty.
That I do not want.
No, that I'm also doing. I'm very strict on this, Mr. Mr. Chaudhary, these type of things I normally don't. know. And you want, I can review that order. I will review that order
I'm
to the
just
order
appealing to your
and then
lordship,
fix it.
lordship, take a lenient view in the.
No, no, I'm not only going to do that, I'm going to review that order to that effect. You want, I can review, very well review, because review is based upon an application being filed on grounds, so that will, I'll review the entire order and then take it up. But I'm not, I'm not. Anyway, let me,
Lordship,
I'll
I
issue
made my
notice.
submission.
Let us issue notice to whom?
Mention to the opposite party.
Opposite party is not there.
Respondent Miller, Bakshi Devi.
How can I issue notice to Bakshi Devi? He's the respondent there, but there's no opposite party here.
In the circumstances, it was done in the context of the lawyer's own conduct. That is why maybe the
Chalo, let us take up the matter some
on some
other day.
other day. Yes.
It's the matter on 11th of August 2020.
The